This afternoon's program, among many of the programs that we do, illustrates well the contemporary relevance of John Marshall. This one in particular, of course, focuses on citations to Marshall Court opinions in the last term. And to help us understand this topic, we have an ideal presenter, Kevin Walsh, who's been a professor of constitutional law at the University of Richmond School of Law for over a decade. He's amply qualified to speak on this subject. He's the immediate past president of JMC. He was a clerk to the late Antonin Scalia, and he understands from the inside how the Supreme Court operates. So we're thrilled to have you here today, Kevin. And with that, I'll hand it over to you.
Well, thank you so much, Trevor, and welcome everybody. This is, we're calling this one John Marshall Citings. I'm really glad that Trevor and I can do this together. The main difference between the two of us as it comes to the subject matter today is that he's actually argued in front of the Supreme Court and is continuing to write briefs and other things that go to the court. And so I hope to go through a bunch of citations to John Marshall in the last term, and then we can talk about what possible lessons to draw from that. Throughout, feel free to type into the Q&A session, and we'll try to get to those as we proceed. So I'm going to now share some slides, and we will kind of move through those, but don't hesitate to use that Q&A, and we will definitely do our best to move through them. So here we are in John Marshall Citings, October term 2020. And I would say that the current term is still going in a sense. They rose for the summer, but until the new one starts, October term 2021, we're still in October term 2020. So there'll be a surprise perhaps for you. So the Marshall Court, right? The Marshall Court is 1801 to 1835. So why should anyone care? This is something people ask me all the time. They say, you talk about John Marshall, why should we care? Well, you know, there's some pretty important government officials who seem to still care. And so one way is to ask them or to try and understand them. And those important officials are judges. So my focus right now is on the Supreme Court of the United States, but John Marshall citations show up in all sorts of opinions, and perhaps we can dive into those in a future setting. So in October term 2020, you had citations to the Marshall Court 30 different times across 18 different cases. Every single justice on the court joined multiple opinions that cited a Marshall Court precedent. 7 of the 9 authored an opinion. Sotomayor and Kagan were the ones who didn't, but you know, it'll be next year. This is just 1 year. And in terms of authorship, Thomas Gorsuch and Alito were tied at 4 for the most opinions, citing a Marshall Court precedent. Roberts came in with 3, Barrett and Kavanaugh 2, Justice Breyer had 1. These were in all kinds of opinions for the court, for plurality, concurrences, all of that. The most common type of opinion, and we're going to see a pattern emerge, I believe. The most common is a dissenting opinion, sort of interesting, followed by concurring opinions and opinions for the court. Okay, and these slides, by the way, are going to also be available with the written materials. These are not the written materials. We had even more robust written materials for you, but these are on the website. So some of these are exactly what you'd expect. The greatest hits: Marbury versus Madison, Mcculloch versus Maryland, Cohen's versus Virginia. I'd say Gibbons versus Ogden is another one that we sometimes see, but this term, these were the big 3. Look at the subject matters. So if you say, what kinds of lawyers who are arguing cases to the Supreme Court might need to know about Marshall Court opinions? Well, eminent domain, assigner estoppel in patent law, standing, officer removal, agency structure, so on. I won't read all of them because we'll go through each of these cases, some in more detail than others. So why are Marshall Court opinions cited? I went in thinking that there are probably 3 categories, namely evidence of prior practice, evidence of longstanding and continuing practice. So that's a little bit different because we might think longstanding and continuing, it's sort of still the law rather than, hey, we just used to do it this way. As we'll see, those two categories end up coming, collapsing into each other. So the kind of, this is how we've always done it sort of citation. And then a different kind is articulation of fundamental principles. And we'll see some of those fundamental principles. Now, both of these kinds of things, unsurprisingly, are staples of the practice of law, right? Because of the way federal law works. And it turns out that a lot of times in constitutional law in particular, but not just constitutional law, it's oftentimes a winning argument, or at least one that has a lot of credibility to say, John Marshall made this argument, right? It's a nice move. So let's see how it's done. Before going into all of the ones from throughout the term, I thought I'd mention the latest John Marshall citing. So the written materials were completed a while ago, right? After the court rose for the summer recess. But as I mentioned earlier, they're still in session. And there is there's a bunch of movement on what some people call the shadow docket. Other people might call it the emergency docket or the lightning docket, or as I kind of think of it as the fast track. These are orders and then opinions relating to orders that come in cases that have not been fully argued. And so the latest one was where we had a John Marshall citation, was a 5-4 order denying a request to enjoin the enforcement of Texas's Fetal Heartbeat Act. So we can talk more about this in Q&A if you desire. But you had this order saying we're not going to get involved, and there were 4 different dissenting opinions. There was a brief per curiam explanation just on behalf of the court. And so Chief Justice Roberts, Justice Breyer, Justice Sotomayor, and Justice Kagan all wrote dissent. Justice Breyer's dissent cited Marbury. Now, one of the big issues in this case was the structure of this Texas law that prohibits state officials from enforcing the law. So it's a prohibition of certain types of abortions that then cannot be enforced by certain enforcement officials, but instead can be enforced by any person having an interest in the matter other than those who are excluded, the enforcement officials. And the challenge that this presented to the challengers, people who would like to have this law enjoined, set aside, right, not be able to be enforced, is that typically the way this works is you sue the enforcement officials. The standard enforcement officials, though, are not authorized to enforce this law. So that was sort of kind of what was going on. And here's what Justice Breyer says. And notice where Marbury comes in here, right? So he says, I recognize Texas's law delegates state power to prevent abortions, not to one person or a few persons, but to any persons. But I didn't see why that should make a critical legal difference. The delegation still threatens to invade a constitutional right, and the coming into effect of that delegation still threatens imminent harm. Normally, where a legal right is invaded, the law provides a legal remedy by suit or action at law. Marbury, right? And this is the part where Marbury, remember, was suing for his commission, and Chief Justice Marshall says, normally where there's a right, there's a remedy. So what's going on here? Justice Breyer is invoking Chief Justice Marshall, right, for this general principle. Could he have stated the general principle just by itself? Sure. Would it have as much oomph? Not necessarily. And so that's, I think, a good example of citing a Marshall opinion for a fundamental principle. And lawyers can do this too, right? So I don't know. I didn't see in the briefing whether this came from the lawyers or whether Breyer came up with it, but cases like Marbury and Mcculloch and Gibbons and Cohens versus Virginia, every lawyer is trained in them, and they become a stockpile of fundamental principles, even in things that have nothing to do with, say, mandamus or the Second Bank of the United States. Okay, so what I'm going to do now is just move through time. We'll move very quickly just to get a sense of the diversity of the holdings in the Marshall citings cases. Then we'll knock out some of them and say, that's it. Hopefully there's not any hard questions. I'm not an expert in, for example, assigner estoppel in patent law. It seems like a good thing to know, but I'm more of a John Marshall guy. So we'll do a deeper dive into the others. And if it gets really tricky, Trevor and I can tag team and we'll come up with some good answers for you. So we're going to see this in time. So the first Marshall citing in a Supreme Court opinion was last December. This is one of the earliest opinions that was released last year, a case involving the Religious Freedom Restoration Act. And the question, the question had to do with the availability of money damages. And so you had a citation to Marshall in this case involving the Religious Freedom Restoration Act. Like a lot of the early opinions, this one was unanimous. When there's dissents, of course, it takes a while to work out. Next, actually, it was not until March 8th, 2021, the case of Uzegbunam versus Prochevsky. This is a fascinating case. And by the way, in the slides, some have links up top and others don't. The linked ones are going to be our deeper dive cases. So if as you go along, you say, okay, we're going to hear a little bit more about this case. But this was a case involving redressability requirement in Article 3. And the holding 8-1, a request for nominal damages satisfies the redressability element where a plaintiff's claim is based on a completed violation of a legal right. We'll talk a little bit more about this later, but I just want you to look at the opinion alignment. This was the first, and so far only, solo dissent of Chief Justice Roberts. Right? He's been on the court for 15 years now. And this is the first time that he found himself all by himself in dissent. Torres versus Madrid. This is a case involving the application of force. The question was it a seizure or not? You had a 5-3 with Justice Gorsuch dissenting. Ford Motor Company is a personal jurisdiction case. So there's a lot of litigation about personal jurisdiction, and this vote alignment 8-0 really masks a lot of disagreement on the court about what's actually going on and how to think about personal jurisdiction. I've underlined Justice Gorsuch because he's the one who cited a Marshall opinion. The court is sort of open, at least 2 or 3 of them are open to rethinking the international shoe approach to personal jurisdiction and kind of going deep. And so this is an example of a sort of the Marshall court shows up here sort of in terms of the way we used to do things. Now April, and we're only on the 5th case, Texas versus California. There was no holding in this case. So, but there was an opinion. So normally in state versus state cases, the Supreme Court can have original jurisdiction, right? So you go to the Supreme Court in the first instance rather than ending up there on appeal. And over the last 45 years or so, the court has been treating this original jurisdiction in state versus state cases as discretionary. And Justice Alito, joined by Justice Thomas, doesn't think they have the authority to do that. So here you have a complaint that is filed by Texas against California, okay, involving property, as it turns out, and the court said, well, and you're not allowed to just file it. You need to file a motion for leave to file a complaint, and the court denied the motion for leave. They denied leave to file a complaint, and so Justice Alito saying we don't have this discretion, and this will be one of our deeper dive cases. Okay, Edwards versus Venoy. This is a habeas case, a question about retroactive application on federal collateral review. It'll turn out that some of the Marshall Court cases on habeas continue to be generative. City of San Antonio versus Hotels.com LP. This had to do with what seems really ministerial, but come on, you know, it's the allocation of costs. Right? Who has to pay for these things? And so there's a federal rule of appellate procedure. And the question was whether the district court had some discretion. And the answer was no. So there was it turns out that courts since the time of John Marshall have been figuring out who to stick with the bill. And that's where that one showed up. Cooley, fascinating case involving tribal jurisdiction. 9-0 opinion by Justice Breyer. So unanimous opinion in June. It has to do with the authority to detain temporarily and then to search a non-Native American who is traveling on a public right-of-way, right? So if you're traveling through on a public right-of-way through a reservation and you get pulled over by tribal police, what is their jurisdiction over you? And the court said there's a jurisdiction to detain temporarily. And of course, the Marshall Court was the source of so much of Indian law. And so it's not surprising to see a Marshall Court citation there. Borden versus United States, Armed Career Criminal Act. The Supreme Court has been has treated certain parts of the Armed Career Criminal Act, which is a very big deal, sort of major sentencing enhancements, but has to do with some of your prior offenses. And the question is what counts as a violent felony. They have a really hard time sorting this out, and the stakes are very high. And so this will be an example of a case where they Thomas and Kavanaugh throw down some Marshall citations on sort of fundamental principles grounds. Nestle USA versus Doe. This involves the Alien Tort Statute, a law that was actually passed in 1789, and the courts are still trying to figure out some of the rules about its applications. The Marshall Court citation here was not a very big one, and so as you look at the judgment, whoa there. Not going to try and summarize that, and I just say read that one. We could do 8 hours of CLE just trying to sort out that holding, but we won't. California versus Texas. This was a really big case, right? This is the Affordable Care Act minimum essential coverage provision, right? California and Texas. The other one was Texas versus California. This one's California versus Texas. It actually started as Texas and some individuals against the US government, right? Saying you can't enforce this minimum essential coverage provision. So the whole Affordable Care Act is unconstitutional. And this was a little surprising to some. I guess the main surprise was the author, Justice Breyer. Those of you who follow his jurisprudence closely know he's not a standing hawk. He's more willing to find standing. But here you had a 7-2 opinion finding that there was no standing for the states or for individuals, even those subject to the minimum essential coverage provision, to bring a challenge. And the reason why is because the penalty for violating that was 0. There's some interesting back and forth, right? This is almost like a mirror image of the Texas Heartbeat Act case in each. So it's hard to figure out sometimes who to sue when no one is threatening you. You don't know exactly who's going to threaten you, or there won't be a threat of enforcement. Fulton versus City of Philadelphia. A little surprising to see a John Marshall citation here. There's a very high profile case involving Philadelphia's refusal to contract with Catholic Social Services. Catholic Social Services was providing, essentially certifying foster families, and Catholic Social Services would not certify same-sex couples. And the city of Philadelphia terminated their contract, and there was free exercise litigation. 9-0 in an opinion by the chief. Fulton, who was one of the foster parents in Catholic Social Services, prevailed, but a very fractured opinion. Justice Alito, there's been a lot of speculation that Justice Alito originally had this case and was writing an opinion for the court, but then lost his majority somewhere along the way. I don't know whether that's right or not, but that's where John Marshall shows up. Arthrex, maybe you haven't heard of this case. It's a big one. It's a really big one, even outside of patent law, because it has to do with separation of powers, and the Roberts Court has been very active in separation of powers. Here, you have administrative patent judges who kind of make essentially final decisions on certain challenge patents. And there was a challenge to the way that they were appointed. And this is a carefully worded holding here, because it turns out that what they ended up doing to fix this was make their opinions reviewable. rather than fixing something about their appointment. They were appointed essentially as inferior officers. And if you're an inferior officer, you can't really have unreviewable authority over certain final big things like this. That was that case. And Roberts, in separation of powers, I think, and when the court and the justices are trying to think of how they define themselves, it's not surprising to see John Marshall's citation. Collins versus Yellen, another huge separation of powers case. In this one, it was Justice Thomas who is citing Marshall. We'll see a little bit more about that. But this had to do with the removal power over the director of the Federal Housing Finance Agency. This was billions, and there was so much money at stake in this case, and an important decision. TransUnion, another big case involving standing. So this was two different groups of plaintiffs who were challenging Fair Credit Reporting Act violations, and 5-4 decision. Dueling, so this was a sort of intra-conservative split, Justice Kavanaugh with the opinion for the court, and Justice Thomas filing a dissenting opinion, both of them relying on John Marshall in different ways. Minerva Surgical, we're almost at the end of the term. Minerva Surgical, this is the assigner estoppel one. Justice Barrett cited a Marshall opinion in dissent. It had to do with prior practice. And then Penny's Pipeline is another Barrett citation of Marshall, this time in dissent. This one's particularly fascinating because you have the most junior justice, right, the newest justice, citing back the great chief, John Marshall, to the current chief, John Roberts. And this had to do with the abrogation of sovereign immunity. So the Natural Gas Act authorizes private companies to condemn necessary rights of way, right? So you're trying to put together a pipeline, right? Penny's Pipeline Company, you got to assemble the land. It's useful to have eminent domain authority. That's something that the government has. In this case, it was the federal government's eminent domain authority. And it was assigned by statute. The federal government could delegate it under this law to a private party. And then the private party in this case was trying to take New Jersey's land, and New Jersey invoked sovereign immunity. And I have to say they had a pretty good argument, and it convinced Justice Barrett and Justice Thomas, Justice Kagan, and Justice Gorsuch. Note, this is not a standard sort of liberal conservative or anything split, right? This is really some fundamental principles of federal jurisdiction. The chief held a narrow majority, and we saw Marshall on both sides. So what? So what? There it is. So I know there was a lot. There's not a test. So why do we care? Well, let's look at how these things work, how these function in legal argument. So you have Marshall citations in 18 signed opinions. They only decided, it was a really slow year. They only decided 55 after argument and briefing. So 29% of the cases, you've got 1801 to 1835 opinions being cited. Now, two of those opinions were in connection with orders, so it's hard to make comparisons. But if we look at the others, you see that really there are these two primary functions. So evidence of prior practice, or evidence of longstanding and continuing practice, or articulation of fundamental principles. Here's an example of a prior practice citation. This is Tanzan versus Tanvir. That's the Religious Freedom Restoration Act case. This is the very first one that I mentioned decided in December. And there's a lot of text here. Sorry, there's so much text on this slide, but you just have Thomas writing for the court, explaining some basic principles about suits against government officials. And the proposition is these common law causes of action remained available throughout the 19th century and into the 20th. See, for example, Little versus Bareem. If you look at the timing of that, that was 1804. This was a Marshall opinion. It involved a case called the Flying Ship, called the Flying Fish. And it was a suit that was able to go forward against a government official. In this case, I think it was a captain or some sort of officer on the ship, who did kind of like a good thing, but it was illegal. He did what he did because he was ordered to do it, but they were still allowed to sue him. And so Little versus Bream was an apt citation there, but it doesn't do too much, when you're arguing. Okay, fine. You got your Marshall citation. Here's another prior practice one. This is that City of San Antonio case. That was the one where I said since time immemorial, lawyers have been arguing over who has to pay for costs. Winchester versus Jackson. True confession here. I never heard of this case until I was preparing for this. And you know what? It's not terrible. If you Google it, you look it up, there's not much to it. It's actually someone filed a suit in diversity jurisdiction, and it turns out there was not complete diversity. And so they show up at the Supreme Court and they're like, there's no jurisdiction. And the whole report basically says the party for the side that won dismissal wants costs awarded. They asked, and it turns out the clerk of the court reported that typically they don't award costs. And then the court awarded costs. That's it. That's the entirety of Winchester versus Jackson. So let's move on. So those are the prior practice ones. So let's take all of those out. There's no reason to do a deep dive. It's not super interesting. They did a lot of stuff for a really long time. That's the law. Fine. So guess what? I just got rid of 8 opinions. So we don't have to talk about those anymore. But what about the others? So 2 of those 8, I'm going to bring them back in because those were cases where you also had citations for fundamental principles. So we've got a total of 12 cases. The deeper dive dozen. I'm going to pick a few, and then maybe we can stop and do some questions, and then have a little bit more for you. So I want to start with the TransUnion majority. So how does this work when you cite for fundamental principles? Remember, here's the holding. Okay, so the pattern here is we're going to look at the holding just to refresh it, call it to mind. So we've done a lot of cases, and then we'll look at how Marshall is cited. So this involved the dismissal for lack of standing because certain plaintiffs, you see, their Credit Reporting Act rights were violated. Okay, there were certain false things about them in their credit reports, but they had no downstream economic harm. It wasn't like they were denied credit or something because of something in these reports. And a 5-4 majority essentially said, yeah, that if your injury is not concrete, like that economic harm, this is a kind of statutory violation, but it's not enough for standing. Sorry. So Kavanaugh is interesting. So this is the only case where we have a Marshall opinion cited for fundamental principles, number 1, in an opinion for the court. It'll turn out that, so you have Marshall cited for prior practice in opinions for the court, but on these fundamental principles ones, normally we're going to see it in concurrences or dissents, and we can speculate about why that is. My speculation about what made this one stand out is that Justice Thomas, in his dissent, sort of brought the John Marshall fire, right? So Kavanaugh is firing back and saying, this idea of requiring a plaintiff to demonstrate a concrete and particularized injury, it ensures that federal courts decide only, quote, the rights of individuals, Marbury versus Madison. Now, Marbury does indeed have those 4 words in the opinion. The modern standing doctrine, though, of course, did not exist in the same form. So this is, I'd say, a kind of, yeah, you cite me a Cohen's versus Virginia, I'll raise you a Marbury. But it's that's really what's going on here is using Marshall to define the court's operations and show that they're doing things that are continuous with the Marshall court. Here's Marbury again, and this one was kind of snuck in. It's and I think it was a little bit. I don't know if it belongs there. might say, hey, boss, we might want to take that one out. A law clerk might say, I know you want Marbury, but why? Well, here we have to do with the relationship between a statutory prohibition or obligation and then a cause of action. So Congress provided a cause of action for these people who were denied standing. And Kavanaugh's argument here is that's not enough. Okay, the mere creation of a prohibition or obligation and a cause of action is not enough for standing. So we cannot treat an injury as concrete for Article 3 purposes based only on Congress's say-so. And again, the Marbury citation, if you download the slides and you click through, you're not going to see, right, a discussion of statutory standing in Marbury, right? Page 178, I did it so you don't have to. That has to do with, like, it's our obligation to ensure the constitutionality of laws. So what we have here is a Marbury cite, not for the general proposition or the specific proposition about statutory causes of action, but for the general proposition of a court's obligation to ensure itself of the constitutionality of a law. Okay, so what about Thomas in dissent? Thomas is relying on Cohen's, and here he's agreeing in part with Kavanaugh, right? He's saying Article 3 does not extend the judicial power to every violation of the Constitution or federal law which may possibly take place. And that's good. That's a good use of Cohen's. Cohen's involve the Supreme Court's appellate jurisdiction to review a state court decision of federal law. And Marshall, it's not often taught, but I'd say Marshall scholars tend to view Cohen's as one of the most statesmanlike of Marshall's opinions. His conception of the Union really comes through, and it's a ringing affirmation of the Supreme Court of the United States as the ultimate authority on the meaning of federal law in cases decided by courts. So it's a nice go-to in jurisdictional cases. So here we have Thomas again, citing Marbury, the same citation as Kavanaugh. They're on opposite sides, but they at least agree that the province of the court is to decide on the rights of individuals. The difference, of course, between Thomas and Kavanaugh is that Thomas thought that this right that was created together with the cause of action was enough to provide standing. Okay, now that had to do with the specific nature of this right. Here's Thomas again. He agrees. So what's happening in these Marshall citations is Kavanaugh and Thomas are agreeing on sort of general principles, but disagreeing on the application of this case. And they're each bringing Marshall in sort of on the general principle side. What's fascinating about this one, so this is a footnote. I gave you the sentence and then the footnote. So the proposition, a statute that creates a public right plus a citizen suit cause of action is insufficient by itself to establish standing. The fascinating thing about this footnote is, but see, right? So, but see, this is sort of, I've given you the proposition, but I'm going to give you now authority that goes the other way. And you might think that Mcculloch versus Maryland has nothing to do with modern standing doctrine. And in a sense, you're right. Modern standing doctrine didn't come around until the 20th century. But what's fascinating about Mcculloch, it's not often taught, is that this was a case involving attacks on the Second Bank of the United States. And it turned out that it was an agreed upon case. You see, the Baltimore branch wasn't going to pay the tax. And Mcculloch was the cashier of the bank. Maryland wanted to sue. Even though the caption of the case is Mcculloch versus Maryland, Justice Thomas is right. This was actually, so for lawyers, this was an action of debt. So that was the cause of action, was an action in debt. The sort of common law writ of debt here, an action of debt brought by the defendant of error. It wasn't actually Maryland. It was a guy named John James. John James was a Maryland official, and he sued for himself as well as the state of Maryland to recover certain penalties. So kind of obscure, but just shows you how these things can pop up in different places. Okay, we're not going to do as deep a dive in all of the others. I'm going to skip ahead to Uzegbunam and Penn East. and then we can always come back. But I think I'd like to open it up a little for some questions. So let's go to Uzeg Bunam. Okay, fascinating facts. So this is that one about nominal damages satisfies the redressability. This was a First Amendment case, challenge brought by a university student, okay, who wanted to hand out religious literature and make sort of religious arguments in the public square of his university. And so he was handing out his religious literature, and campus police said, "You got to stop doing that. That's against our rules." So he did, and he went back to, and then he looked up and he's like, "Don't I have some rights here?" And then he decided that he, could. And so there was a challenge that he kind of argued with the university, and the university is like, "Okay, you can do your free speech thing, but in this like tiny little zone, and that's going to be enough for you." And he did that, and it wasn't that effective. But still, they're like, even though you're in this tiny little zone for your free speech, you're kind of bothering people, and so you got to stop. And he's like, "Well, that's not right." Like, but he stopped. So this is America, and he sued. And after he sued, right, he said, so it's a backward looking claim. But he's not asking, right? What he really wants is to be allowed to speak and not have campus police say, "Hey, buddy, pipe down, go home." And that's what he really wants. But it turns out that they were willing to give that to him. So he sued for injunctive relief as well as nominal damages. And this is important, and it's something that very, very important in constitutional litigation. Always include your nominal damages claim. Why? Because, and this is the way I'd always taught it, is that it will prevent mootness. Well, it turns out the 11th Circuit disagreed. And they had some circuit precedent saying that sort of nominal damages was not enough to keep alive his claim, that what he really wanted, they had already given him. And so the case just couldn't go forward. And you might think that that's just a kind of a small little thing. The case can go forward. Hello, attorney's fees to a prevailing party, right? You can't be a prevailing party if your case is dismissed for mootness. And so even though the damages were small, the question of whether nominal damages, like, damages in name only, like $1 or $3 or $4, right? Just as a kind of sign that they were wrong and you were right. And 8-1, the Supreme Court made it so I did not have to change the way I teach federal courts, the way I teach mootness. They said that is enough to keep it alive. And John Roberts said, "No, it's not. No, it's not." And he was all by himself there. The chief often, by virtue of seniority, he always can assign an opinion when he's in the majority because he's the senior by virtue of his office. But here he was dissent, so there was no one else to write it. But he only writes dissents when he feels very strongly about it. And what's interesting about this Marbury citation is he's saying the judiciary is authorized to say what the law is only because those who apply a rule to particular cases must of necessity expound and interpret the rule. So go into some comment boxes sometime, check out Twitter. You see people arguing if they're criticizing the court, especially, they're like, "Show me where in the Constitution judicial review is given to the court." You're like, "Where's the judicial review clause?" Well, in Marbury versus Madison, what Marshall did was say it's emphatically the province and duty of the judiciary to say what the law is. That's that first part. And then his next sentence is, "Those who apply a rule to particular cases must of necessity expound and interpret it." In other words, the power of judicial review, right, to hold laws unconstitutional is incidental to the duty to resolve cases in accordance with the law. And that's what, so you can see why this is an apt citation for Roberts, because Roberts is saying there's not really a case anymore. And here it's like putting the cart before the horse to say we have to have nominal damages available so that the judiciary is able to speak to these important First Amendment issues and to vindicate these rights. And he's saying that's backwards, right? We only speak to the Constitution because we have to decide cases. So it's wrong to argue we should have this case still alive so that the judiciary can decide it. Interesting. Also, I recommend this opinion. Roberts, of course, is an excellent stylist. And right at the end here, you have his nice alliteration. He says, perhaps defendants will wise up and moot such claims by paying $1. Okay, just pay the nominal damages and maybe that'll be done. But it's difficult to see that outcome as a victory for Article 3. Rather than encourage litigants to fight over farthings, I would affirm the judgment of the Court of Appeals. Roberts can get away with that. I would not put that in a brief, but good for him. All right. And let me take out one more, and then we can pause. I don't see questions in the Q&A, but Trevor and I can discuss sort of if I've provoked anything from a practitioner point of view. And all right, last one for now. Penn East Pipeline. This was that eminent domain case. Here, okay, another opinion from the Marshall Court that I never heard of. And is in Chief Justice Roberts' opinion. This isn't the main event in this case of the Marshall citation. So here this is just a citation of a case. It's actually a suit by one of Martha Washington's grandsons, who is trying to stop an inquisition into the value of land. So, so the federal government was exercising eminent domain authority. Notice in areas subject to exclusive federal jurisdiction. So there's a lot going on in this case, right? Where does the federal government's eminent domain power come from? Now, a lot of people think, well, they're the federal government and, you know, the federal law is supreme and eminent domain's like an important power that any government needs to have. So the federal government must have it. Well, that's not actually very sound reasoning, is it? Because generally you would have a government that has enumerated powers, right? The federal government is a government of enumerated powers. There's a whole list in Article 1, Section 8. And then you have the necessary and proper clause at the end, which is the hook for implied powers. This will turn out to be important to the case because normally when Congress is exercising Article 1 power, so Commerce Clause legislation, okay, 25 years ago, there was a 5-4 decision, maybe wrong, but still the law, that Congress's Commerce Clause legislation can't abrogate state sovereign immunity. So a private individual sues a state to enforce Commerce Clause legislation, they will not be able to get money damages. The state will claim immunity and the state will win. Abrogation is a kind of busting through the immunity, and you can't do that with normal Article 1 stuff like Commerce Clause. Well, what about eminent domain? Well, it turns out that when the federal government is the party that's suing, states don't have sovereign immunity, which, by the way, is in the Texas Heartbeat Act case that we saw earlier on. That's why the United States is now suing Texas, because Texas itself does not have sovereign immunity in a suit brought by the United States. So how does this all come together in Penn East? Well, it's not the United States versus New Jersey. It's Penn East Pipeline Company, LLC versus New Jersey. That is not a new name for the United States, but they are exercising delegated authority, right? And so part of Marshall Roberts's reasoning here is Penn East Pipeline Company is standing in the United States' shoes, so we have special rules about sovereign immunity and we can break through it. Justice Barrett would have none of this, right? So here's Justice Barrett's dissent. And she's making the point here that the Constitution does not have an eminent domain power, okay? Now, the Supreme Court has recognized that the federal government has an eminent domain power, but that's been recognized as an implied power. So an implied as necessary and proper to the exercise of other powers conferred upon it by the Constitution. So here's Barrett's move. There is no standalone federal eminent domain power. Okay, that's what she's saying here. So when the federal government's doing it, it's always in this case with the Natural Gas Act, which is it comes from the power to regulate interstate commerce. It's just using its commerce power. And so there's nothing special about the fact that it's delegated from the government. Yes, if the United States itself had sued, then sure, there's not sovereign immunity. But that's not what happened. And so you have this article. So where does Mcculloch fit into all of this? And this is what's interesting. Mcculloch is definitely, right, it's the biggest Marshall Court case, not Marbury. Mcculloch is. And it's taught and understood and is in many ways a very broad understanding of federal power. But even there, right, Marshall is saying and does say this is a government of limited powers, right? Because in the course of setting forth fundamental principles, that's going to be one of them. And so you have Barrett kind of bringing Mcculloch to Chief Justice Roberts in a way that is trying to outflank him on continuity with the past. So I have we've got more cases, but now's probably a good time to stop and open it up, and Trevor and I can talk. I'm going to turn off my screen and pop in.
Thanks, Kevin. That was really interesting. And I would love to have a conversation with you, but I would love even more to make sure we answer any questions that attendees might have. So while Kevin and I chat, please feel free to put some questions in the chat box or in Q&A, and we'd be glad to address them.
So Trevor, I was laying down a lot of law and stuff like that, but I mean, I'm enthusiastic, of course, but what about from a practitioner's, point of view? Can you glean any useful things from this pile of information that we've gone through? What stands out?
Yeah, well, actually, I was a little surprised by how much currency Marshall era opinions had in these opinions. I wasn't expecting to see that many, and it may be because I think practitioners, frankly, might not be as willing to cite an opinion that old as the court itself would be. And I was musing to myself why that might be. I mean, one reason is that the court, has much more time to craft in its opinion, and each opinion, and delve deeper than practitioners might, even at that level. But you asked the question, and maybe just wondering out loud whether one of the citations had come from somebody's brief, whether that was something the court stumbled on itself or whether it came from a brief. And for all the reasons that you described, a practitioner might be motivated to cite a Marshall era opinion, either because it stands for a fundamental principle or because of evidence of past practice or longstanding practice. But it occurred to me a couple of reasons why a practitioner might not be as willing to cite it, in that, often the most sophisticated practitioners, at least before the Supreme Court, have their case aimed at particular justices. And they might be motivated to cite to that justice or justices they think are swing votes, cases that those justices have decided. Even if those opinions that they're citing ultimately cite back to a Marshall era opinion or principle, they want to put it back in front of the justice. Look, you basically decided this case before. This principle came up in this case that you decided, Justice Kagan. That's certainly a tactic that is used at all levels of the judiciary. But it occurred to me that that's probably one reason why an opinion might not find its way in a brief, but it would find its way into an opinion. I also noticed going through the very comprehensive presentation, Kevin, that often the cases were cited, but there was not language quoted from them in most circumstances. And I think a court is more apt to do that, to just cite a case without explaining why you're citing it. Because as a practitioner, you're trying to make it easy on the court. And in some ways, you almost justify why you're citing a case by either quoting the language in the text and then citing the case at the end of the sentence, or citing the case in a citation and then in parentheses, explaining why you're citing it. The Supreme Court doesn't do that as much, doesn't need to. in the same way that a practitioner might. And the language of 200 years ago doesn't flow as easily as more recent language might. And so perhaps a practitioner these days might be less apt to cite something from the court than from the martial court than the court itself would.
Yeah, it's interesting because when I looked at the sort of pattern and one of the slides that I didn't dwell over, and you think what's really going on when you see these fundamental principles citations and they're in dissents and concurrences, that's typically right because you've sort of lost on more proximate authority. So you have a sort of the sort of local authority, the stuff. This is about the meaning of one particular precedent and the best understanding of it. And then you have a dissenter or maybe a concurrence in the judgment, someone who has a different approach. But it's not that they have nothing, right? It's just that on the sort of more proximate, they're then trying to add in and saying, well, look, I'm going to sort of rope in Marshall here. And I think perhaps, so that's not so great for lawyers, right? Because you want to lead with your, I win on the sort of what I call the local, that is the sort of stuff immediately surrounding this area of law. But it's Marbury, McCulloch, and Cohen's. Let's go back for a moment. I'm going to put my slide back up for the Heartbeat Act citation to Breyer. So because I do think this one, it's California versus Texas. This one is particularly interesting. Whoops. Right, because it is a novel setup under the Texas law, and the novel and complex procedural questions that sort of were bedeviling the case at the stage that it reached the Supreme Court were the reason the majority gave. And I do think this is an example where a Marshall citation is better than no citation at all, and where a kind of sort of it's really ultimately an appeal to like basic sort of justice, right? Where there's a right, there's a remedy, but it feels a lot more lawful, doesn't it? Right, a lot more authoritative and lawyerly, to use John Marshall's words.
Absolutely. I mean, if there's something on point, it sounds a lot better when it comes from John Marshall's mouth than just from the lawyers. And I should say that most practitioners don't practice at the U.S. Supreme Court, at least not often. I was lucky enough, as you said, to argue a case there, but that's certainly not my day-to-day experience. But you're much more apt probably to be discussing Marshall's opinions at the U.S. Supreme Court than in your typical federal district court, because district courts and even federal courts of appeals are bound by superior, vertical precedent. And once you get to the U.S. Supreme Court, yes, they're bound by their own decisions, but they're much more concerned about first principles and have much more ability to go back to what the original purpose of an area of law is and rehash and re-explore the purpose of different provisions, whether in statutes or the Constitution. And so they're probably much more free to go back to those original and resort to those first principles the way that the Marshall Court was doing it for the first time back in 1801, 1835.
It's interesting. Because I can think of a couple of cases that either I had litigated or am familiar with friends who've litigated or something like that, where they have, and not Supreme Court cases, but maybe a Supreme Court of the United States, but maybe Supreme Court of Virginia, or even a circuit court case. There's an interesting separation of powers case. It ended up at the Supreme Court of Virginia, but the winning argument in the circuit court was Fletcher versus Peck, kind of, right? This general principle that we're not going to look into the motives of legislative bodies. And you're right. I mean, if you've got a more on point case, you should cite it. But if you don't, you're not without authority, right? Like a lot of times, if you think there ought to be the Marshall opinions kind of, because it's Marshall, right? It helps to have it in his words instead of your own, I suppose, regardless of where you find yourself.
Yeah, I mean, he's such a revered figure that, more so than most other justices or chief justices, he has staying value than the others, and his writing style is plainer than most and more accessible than most, such that the way that he expresses an idea, it stands the test of time. And I feel like in my much more limited review of his opinions compared to you, Kevin, it's much more readable than many of the court's opinions, even for the next 100 years after that. The 1870s, 80s, 90s sort of get lost in legal analysis, such that Marshall summarizes an idea very succinctly in something that would take half a page for somebody to talk about later on.
It definitely, and it's interesting too, because one of the things that stood out to me here was that, we can take pot shots and say that's not exactly what Marbury was about. That's not exactly what Mcculloch was about, but no one cares, right? If it's accurate and if he said it and if it captures a legal principle nicely, then it's so much better than just your own say so. And the thing that this is often, I think, infuriated some of Marshall's critics is that in these opinions, you often find a little bit for both sides, right? Before kind of in stating the general principles. And so the citations to Mcculloch were a good example of this, where Mcculloch is a case involving expansive understanding of federal power, but the cited and quoted stuff is for even John Marshall recognized there were limits on this. And so you, current chief, step back a little. Now, when I had tried to summarize potential arguments or potential takeaways, here's what I'd come up with, and we'll see what you think. One is John Marshall's for losers. That's why you see him in dissents and stuff like that. That said, I think maybe not. I mean, you know what? There's still Supremes. John Marshall, but how about this? Like, when you've got nothing else, you can still have John Marshall. That's pretty good. Another worry, this is a sort of another take, might be you're just gilding the painted lily, right? You're just kind of doing stuff, and so lawyers shouldn't do that. But this last one, I think is kind of interesting. So the originalist dilemma for John Marshall is kind of John Marshall has such authority that, say, originalist judges are kind of in areas where he might have something. He was on one side of big constitutional debates, sort of what can you actually kind of go around Marshall or not. And what I find here is that I'd say that dilemma is overstated, because a lot of times your impression of what the Marshall Court opinion might have said might actually not be right, or it might be incomplete. So there might be more there than you think to cite for the opposite side. Well, I know we're short on time. You all in your Q&A have been merciful. You haven't given us any curveballs or screwballs or anything. I bet we can find Marshall citations everywhere, though. But thank you for being with us today. And Trevor, why don't I put my screen away, and can you take us away?
Sure. Thank you, Kevin. You've given us a lot to chew on and to share with our family and friends over the dinner table tonight and in future meals. So thank you very much for this presentation. And for those of you in attendance, thank you for coming and being with us. We offer public history and civics education programs to students, teachers, attorneys, and the general public. And you can find all about that in our programming at johnmarshallcenter.org. One of the activities we offer is the Marshall Scholar Series. It's a public constitutional history program that connects the public with experts and scholars in the fields of law, history, and government. Some of those programs, like this one this afternoon, are offered for CLE credit. And I should note that the written materials related to this program are available on our website right now. So if you go to the events tab and click on the listing for this event, you'll see a link to the CLE materials. And if you're interested in CLE credit, as I mentioned at the beginning, you will be emailed a form to complete. And please tune in to future presentations. I think by virtue of signing up for this, you should receive our emails moving forward. And we warmly invite you to future presentations and hope you'll join us then. So thank you. Have a great evening.
Thank you, Trevor. Good night.